Bana Tula Lere. Kale abanange bali kuba nti n'okumutugoberera Dr. Kizza Besigye nga atuuse essaawa zino mu kkooti wano yadde tanaba kubeera nti nno ayingirizibwa mbadde ki tabanga networka Lord Mayor mulabyeko naye atuuse Lord Mayor Senior Council akusobodde okuba nti no atuuka mu kooti wano eno nejjudde sitamba andiyitaddawo esatu wano mulimu oba oteeka eno teriyo ogenda kuteeka ekitegeeza atumatulina agenda akwatira wandiyitaddaani wali walina akali Lord Mayor asobodde okuba nti no atuuka mu kifo kino so kitegeeza nti omusango anytime from now era listed okuba nti no omusango muwulirwa kati kusaawa Lord Mayor ne state council wa state erivumbuka bali mu kwebuuzaako aga tunalinda chief ojja kulaba oyo oli mukulaba ali mukwogera ne Lord Mayor ye state ye council wa state biri kumbuka atuuse. Sorry, excuse me. Bagenda bita jangu mubeereko bana mubeereko temuvaako. Abantu bamujja emmotoka.
Doctor! We shall never surrender!
Amaze okuba nti natwalibwa munda kale tobatuddayo. Tukuwa sauce.
Umuntu amu bagumye.
Genda okwate nawe genda okwate tanatuuka genda okwate tanatuuka
kamera bayingire
kale wano wentudde kati kantuuleko kati abamu kale amazima woba ogenda wandika script siraba nsonga lwaki ogenda kujja eno tunyigirize
naye ngenda kukwata toteekawo mbeera naye ngenda kukwata toteekawo mbeera lwaki oteekawo embeera gwe yimirira okwata ebiryo lwaki oteekawo embeera kati oyagala ate nkudde mu maaso oyagala nkudde mu maaso kyotamanyi obuuzaawo looza ndi musiro okubanga nyimiridde wano nga ndi mugundi anyway ndakudda saidi zaawe jonjo yitanze ngenda kukwatira
aba agenda kukwata ali mu kutusokera disturbing people Any TV waliwo nyiniyo ate nitiriga agenda kukwatira wa ate nange njagala wano tegedde mwana wa street tusula taapa kino kiri wamu
olabe eno tripod
kati mutoti omulamuzi tugenda teekayo oti oba oyagala
eno naawe
kkiriza tukutume
gwe mwana
ayagala
ojja
gamba
kunsasula bwe mugambe mutwalo
teekayo microphone sebo
omugambe mutwalo ku gumu bbiri ayagala data banne abatulaba tuli mu kooti wano Nakawa. Kooti eno yosekerwako mu nsengeka ya kooti eziri mu Uganda era abakulu bano babadde newankubadde baba committee nga to high court naye abalinawo application eyali pending oba application eyali esigadde okubanga ekolebwako era bannamateeka babavunaanibwa bano ensonga lwaki bazze mu kooti eno bamanye kiki ekituufu ekiddako ku nsonga ze bateeka mu kooti eno nga beemulugunya. Dr. Kano Kiza Besigye ne Haji Obedi Lutale ne afande gwe bali naye bavunaanibwa emisango egiwerako okuli ekigambibwa nti baalya mu nsi olukwe, baali baagala kumaamula ku gavumenti eno eriko, nti baakuba enkuŋŋaana mawanga agatali gamu nga lwe lukwe lwe balina okujjako gavumenti. Akati tuzze tulabe application ki gye boogerako newankubadde ng'oludda oluwaabi olinamu ku ssente tekewa sewo kale sewo ogenda kunkolako sewo tuli mu kaseera katuufu kansubire teri mulala ajja kuntawaanya otawaanyiza olwaleero naye kaadi egudde naye ogiraba naye osirise okitegeeza
kati olaba nsobola ogizaayo
eyo kaadi yammwe amwana andika naawe salala byakuntawaanya alindako katono
naye kati kyanjo alabe kyanjo musumbuye
leeta
agenda kuvayo ng'alutawaana
wa sina wempita giwoyo
waye
isana
alright bannange abali mutulabira from different parts of the world. People watching me from England. Wow, I love that. Ali mutulabira England. Extreme media etuuka na England tuli babi Amos agambe ali mutulabira from England ate Nicholas agambe is in Ibanda kirungi. That's great. How is England and how is Ibanda?
awebibanda talina kyatugamba
Owebanda tasobola kyebo okimanyi owebanda asobola osindika sente
talina kyatugamba
bano abeigirandi ennaku zino tebagaba sente. Owebanda asobola osindika sente wama abeibanda mwebale kubeerako. Sajja ali wano ali mukubajongera
owebibanda talina naawe kyatugamba ibanda oyogera ki owebungereza waali
owebungereza naye maama
kujoka
bungereza bano kale mwebale nnyo okuba nti nomwekumudde ku Extreme Media UK tuli live mu kooti. Paulo Mukama. Paulo Keke is quarreling. Ayomba is quarreling. He wants to teach us. Paulo Keke is quarreling. Besigye quarreling. Ali mutugamba tujeeko amalala amaalo mwogera nnyo omubaka bulwamu. It's not a sign of professionalism at all. Sungu bungi.
Mbuuzi afunye ku kyenkya.
Paulo wafunye ku kyenkya.
Ate nnafuna kyenkya afuna akakomando.
Abaana bano.
Naye akakomando n'amazzi gali agakaveera.
Abaana bano.
Ja kujjonkera.
Paulo munawe olwatusonyiwa. Olwatusonyiwa munawe tuba twogera nnyo mubaka bulwamu. Tusonyiwe taata.
Tuli bulungi naawe tubeera tutya obulungi nga bwe tuli bulungi yabuuza
Paulo munange tusonyiwe.
Tetuli bulungi nveeko.
Paulo agambe
Musajja wa akakkanya Keke ojja kusala omuliro. Ffe ne twagala tujooga.
Alo. kale bannange wala kuba nti nomutugoberera yona gye musinzidde oli live extreme media UD tuli mu kooti era nga ekitakiza Besigye atanaba kuba nti nowaleetebwa naye nga nawe mulabye emabegaawo atuuse ku kooti naye mu kooti munda manyi bino ebintu byanjawulo ali ku kooti naye muno mu kooti muno tanaba kutuuka naye nga katuusutuledde ali mulabye ebifaananyi so okyogenda okukola kubeerako sabusikodinga lakinga evidiyo
kisobola kwala ki kubanga kuba nali mbazenamwe ba edita bana nange n'omuntu gwe tugenda okukola oba kamera nabo bayinza basatu oba babiri tegezayoba balenga munaana tufune outside vaini telezoni kati kamuga
yo
Kaba kuba eriiso ery'obukambwe ngamba musajja wange omuli nga musajja wange yakola yesuulira awo
agamba baaga
yange oba olabanga eri awo saagala enveeko abasajja bagundi bayinza ogibba olaba batuya naye kati saawa zino mazima ddala saawa zinoaki wakoze ki ekikutuuyanya toyina sweta mazima ddala olabye endowooza kyeggambye olimba wandikatadde wano kusawo kandi wamawo wame babanka yeguno yabona agamba nkwamuleti bane
bana tunaba kutandika yona okulasi
zigisazeeko kwate wete ekintu ekyamutuukako baaba eba kubanga kampani kamera yiyo kale Debola zungula tuwaya tobe Debola tekayo microphone wow. Wait, young music. More sound. Message inaenda jipelekaje kulagera hiva ya kudamu. Jiongeze wako. Nachokanga. Never surrender, we shall never surrender. Never surrender, we shall never surrender. Never surrender, we shall never surrender. Never surrender. Never surrender. We shall overcome someday. Deep in my heart, I do believe we shall overcome someday. Seven will die someday. Deep in my heart, I do believe seven will die someday. Those are will find someday. Deep in my heart, I do believe those are will find someday.
This is application number 125. That is Uganda versus Kano, Dr. Besigye, Haj Abed Chale, Captain Denison.
Richard Billy Zumbuka, Chief Secretary, appearing together with my colleague, Jerry Madore, Chief Secretary also, for the applicant, and the respondents are in court. The watchdog to request my senior colleague, the judge of the road may introduce the defense.
It's your worship, my name is Cornelius. Bayan Tulinawe, Bosco Villamudira, Isaac Wagara.
Just do a bit slow.
Bayan Bosco Isaac Wagara, Abshadona, Amaka.
Please switch off your phones or you put them in silence or vibrations.
Your worship, this is an application by the state. For extraction of the respondent's devices and retention. When this matter came up some time back, the applicant wanted to proceed, but the respondents, through their counsel, made an application to have the deponent of the applicant's affidavit cross-examined. This is just to bring you to speed. Cross-examine. The applicant also wanted to have the matter heard in chambers, something which defense counsel vehemently objected. The trial magistrate, chief magistrate ruled that the matter would be heard in chambers for the application. But defense were not contented. They informed the court that we were seeking a revision in the High Court. ask this Honorable Court, one, hold the proceedings in that application. What the file, High Court, and three, avail the record of proceedings. You had objected to that. The issue of holding the proceedings, forwarding the application to High Court, and also to avail defense with the record of proceedings, because it is not one, or they are not part of the functions of the trial magistrate handling such an application to do in case the respondent or one of the parties opted for revision. Out of respect and courtesy, the trial magistrate allowed and availed the record of proceedings, put it on the ethics, and also.
I'm sorry to interrupt your question. We are at the loss of what is he proceeding with the matter? Is he not proceeding? What are we here for? Because what we are listening to does not matter.
Your Worship, I'm just bringing you to speed because you're not part of this application before. And I think I'm important.
But there is a record, there is a file. There is a matter before you.
Counsel, let him just conclude.
So when this court allowed counsel for defense in the lesser judgment intimated that the court that they had filed an application for revision in High Court. But it has never come to us. So our prayer today, Your Worship, is that it looks like there is no such application in the High Court, and as such we pray to have this matter fixed for hearing. So,
Please, Your Worship. Just for the record, whatever he has said here is neither here nor there. The application is there. The application number was presented to this court, and even as the court was supplied to the court. So that is absolute. We say this is absolute coverage that we do not file the application, and it's misleading. But that's not the point, Your Worship. For the proceedings of today, the seeking to proceed. Your Worship, would like to call on record. We have a prayer to make. We have received instructions from the respondents, the applicants, Your Worship, to ask you to recuse from this matter. Your Worship, if it pleases you, these are the following grounds. One, Your Worship, have gotten instructions to raise a complaint against you before the Judicial Service Commission. On grounds of maladministration of justice, incompetence, and abuse of the judicial office. Your Worship, a copy of the complaint which is already filed before the Judicial Service Commission is here for record purposes. Your Worship, you may substantiate the accused or the respondents in this matter have gotten reasonable fear and apprehension that you will not have the requisite competence to adjudicate a matter of this nature and to dispense justice, considering the antecedents and the proceedings that have happened before. First of all, the propriety of these proceedings, Your Worship, being manifestly unconstitutional. Last time the matter appeared here, the state indicated that they had finalized all the investigations they wanted to conduct and proceeded with the conduct proceedings, Your Worship. Under Section 168 of the Magistrates Court Act, Your Worship, this Honorable Court ceases to have jurisdiction over a matter that is triable by the High Court upon conclusion of the pre-trial processes. Once the state has summed up its case, paired the committal papers, and the file is forwarded to the High Court for purposes of trial, this Honorable Court is deemed to have exhausted its jurisdiction and has no residual powers whatsoever to handle any interlocutor application like this court is promoting. It's the first of its kind. If I may bring myself into the picture of the proceedings. In my 28-year practice, I have never witnessed such kind of proceedings. And I'm sure many lawyers will attest to this fact, including police officers, that after committal proceedings are done, that there can be any other application to be entertained by a chief magistrate whose jurisdiction is restricted to pre-trial processes. So on that basis that the respondents here. Are convinced that your worship you have demonstrated gross incompetence in managing matter, this matter, the grave offense that has reaching implications as far as their lives are concerned, which carries a death sentence. The matter that carries a death sentence means what? The other grounds, your worship, is the failure by this honorable court to comply with the dictates of the Constitution under Article 23 and Section 76 of the Constitution, rather of the Magistrates Court Act. Which provisions were cited before in your worship, and they are coached in mandatory terms. That once an accused person has prolonged 180 days before court, they are entitled to mandatory period. And this honorable court cannot conduct any other business apart from addressing itself to the question of matter. And the practice guideline is what now we want to bring in the worship, particularly guideline number 10.2, paragraph 2, which requires you, if you decline to grant mandatory pay, to forward the matter file to High Court for that particular purpose. Your worship, you did not pronounce yourself on the question of whether the accused persons have spent more than 180 days of mandatory. You have never ruled on that one. You have never made any ruling. In which case, you will proceed to determine whether they are entitled to mandatory pay or not. If you find that actually you lack the requisite jurisdiction because of the patterned practice guideline. Yes, you fall back on that guideline 10 and forwarded the file to High Court. That was never done. That is also considered as an act of gross incompetence on the part of the. Finally, your worship, the applicants are relying on the authorities of Attorney General of the Republic of Kenya, the applicant, versus Professor Anyangunyo. This is an East African case. The East African Court of Justice at Arusha, application number 5 of 2007. Your Lordship had this to say, that for the purposes of the application for recusal, we do not find it necessary to delve into the controversy on the test that Dr. Bria addressed us on at length. We think that the objective test of reasonable apprehension of bias is good law. The test is stated various, but amounts to this. Do the give rise to a reasonable apprehension in the view of a reasonable fair-minded and informed member of the public that the judge did not or will not apply his mind to the case impartially. Needless to say, a litigant who seeks disqualification of the judge comes to court because of his own perception that there is appearance of bias on the part of the judge. The court, however, has envisaged what would be the perception of a member of the public who is not only reasonable but also fair-minded and informed about the circumstances of the case, what it would be. Before I make my submissions on this, I would also like to quote the authority of the Livestock Betting and Game Licensing Committee. It's an expert application. This is the common law. This is an English decision with the Supreme Court. And the principle they cited, the House of Lords, is that the policy of the common law is to protect litigants who can discharge the lesser burden of showing the real danger of bias without requiring them to show that such bias actually exists. The point here, Your Worship, an application for recusal is largely premised on the perception of the applicants, of the accused person, whether indeed this court will dispense justice or not. And in this particular case, Your Worship, on the basis of these authorities and the evidence before you, the accused persons are convinced beyond all shades of doubt that you will not dispense justice in a free and fair manner or impartially. Having manifestly demonstrated bias against them, and also ignoring the dictates of the Constitution, to the extent that they are now languishing without exactly knowing what their fate is as far as mandatory bail is concerned. They don't know. After crossing over 180 days without committal, they don't know. So we do pray that Your Worship will be pleased to accuse yourself and terminate these proceedings for this offering.
Much obliged, Your Worship. Your Worship, I wish to join issue with Senior Counsel Elias Lugwaku. I state that for the record, I am doing now. Your Worship, in further submission to our application for recusal and proceeding under guideline 7 of the Constitutional Recusal of Judicial Officers Practice Directions of 2019. The Constitutional Recusal of Judicial Officers Practice Directions of 2019, wherein section 7 states, guideline 7 states that the proceedings may apply to a court or a judicial officer to recuse him or herself under the following circumstances, and we are interested more in sub-guideline E, that where a judicial officer makes inappropriate comments or exhibits unacceptable conduct in the course of the hearing, and in F, where a judicial officer exhibits actual, implied, or apparent bias, then they are bound to recuse themselves. Your Worship, the inappropriate comments that our clients think that should be the basis of your recusal are when you stated that A1 and A2 waived their right to legal representation by telling their lawyers to do what is more urgent at that time. And it was your view in open court, and the record shows that you stated that they waived their right to legal representation. Your Worship, we bring it to your attention that under Article 23 and Article 28, 3E, a right to legal representation in a capital offense can neither be derogated or waived by an accused person. And it is the reason why that specific article provides that in circumstances where private legal representation is not available, the state must avail or provide a lawyer to an accused person where the offense can lead to death. And I beg to read the specific clause in verbatim. That in the case of any offense which carries a sentence of death or imprisonment for life, the accused person shall be entitled to legal representation at the expense of the state. That not at any one point can an accused person waive his right to legal representation in a capital offense nature that can arise to him being convicted and sent to death. That in any instance where he or she cannot afford, no private lawyers are not present, the state shall provide a lawyer to make sure that the right to legal representation is upheld at all times, Your Worship. Your Worship, that position was stated further by the Constitutional Court in the decision of Grace Peter and Fred Varium Maisho versus Attorney General. Where the accused persons were charged with the offense of murder, and it was stated that a right to legal representation which rationale is provided for in Rule 6.1 of the Judicature legal representation at the expenses of the state, Rules 2022. That the accused person shall remain represented pre-trial and during the trial, and where applicable, post-trial in capital offenses. Your Worship, our submission is that that right can never at any one point, and if this court at any one point wishes to form an opinion that since pre-trial is not the actual trial, that decision and the rules resolve that to say that the accused person shall remain represented pre-trial, during the trial and post the trial by legal representation. And if there is no availability of a private lawyer, the state shall provide a lawyer. And therefore, in summing up, we find comfort in the authority of Eastern and Southern Africa Trade and Development Bank and another Eastern and Southern African Trade and Development Bank and another versus Martin Ogang, wherein the test for recusal was explained to say on page 7 and paragraph 34 that the test is not whether
Where's the citation?
reference number IB
Repeat Eastern and Southern.
Eastern and Southern Africa, Eastern and Southern African Trade and Development Bank, and another versus Martin Ogang, reference number IB 2000, and the issue was recusal of Mr. Justice Ogola from the case, and the test is why it was explained to state that the test is not whether Mr. Justice Ogola can disabuse his mind of any knowledge he may have of the respondent, but rather whether a reasonable man having this background information would reasonably suspect the possibility of bias on the part of Justice Ogola. I beg that the record reflects that passage. The test is not to ask whether Mr. Justice Ogola can disabuse his mind of any knowledge he may have of the respondent, but that whether a reasonable man having this background information
But
would
I
reasonably
wish counsel should be submitting while we have the copies of what they are saying in our hands. Should they having them? Should they have them? So that we can respond.
Thank you, and we shall avail. You don't need to be in a hurry. But rather, that whether a reasonable man having this background information would reasonably suspect the possibility of bias on the part of Justice Ogola. And it's our firm submission on the instructions of our client that if any reasonable man has been in court present in conduct of these proceedings, they would form a view that the judicial officer, who is you, your worship, is biased. And therefore, the requirement and to protect the sanctity of the rights of the accused person is that you recuse yourself. But if that argument is disregarded, the fact, much obliged, Your Worship, the fact that you are now a respondent with the applicants in a complaint at Judicial Service Commission is sufficient that you cannot now dispense justice against a person who has complained on both your conduct and your competence. Judicial officers are not robots, they are human beings. And therefore, we beg and pray that you recuse yourself from this matter for it to proceed independently and impartially. Much obliged, Your Worship.
In response,
Your Worship, we object. We object, and if the law still works in this court, which we are not sure about by the conduct of the last proceedings, the rules I've just cited and the ones we are proceeding under, which are the rules of recusal, do not envisage under any circumstance where a state responds to an application for recusal. The rules and the procedure for recusal in instances where a party arises is that the party arises, the judicial officer has an opportunity to respond, not a state attorney. And therefore it would prejudice our application if the rules are not followed to an ultimate realm. And we pray that they operate in this court for at least today. The state attorney does not or is not given leverage, and I will share the rules if it does not happen, much as I thought they are public documents which you should have. They do not envisage a state attorney responding in such an application, and we pray that you, the judicial officer, you respond, and we shall be happy if you recuse yourself, and if you don't, we shall now seek other avenues. But we pray that he does not respond and the rules operate in this court for today. Much obliged.
Yeah. Yes, Mr. Long. So the ruling on the application for recusal made to court will be made on 26th June. The ruling on the recusal application will be made on 26th June. Order. The matter is adjourned to 26th June.
It has been adjourned on 26th. Omusamba gwongezezaayo akangena kuva mwezi 27. Enaku z'omwezi 26 bayongeza omusana ekumi. Naye kyemanyi omusamba gwongezaayo paka ng'enaku z'omwezi 26. Mbagala nyo bali kuba nga mugoberera mu subscribing, naye kyemanyi bayinza omuta 26 okusinziira ekimu agali mu kuwulikikana 26 ayinza ovaayo. Mu subscribing